let me just be clear because I am free on that day. Do you have any materials given you on welfare legislation? Because there are two laws that are included there. One, the GSIS law. Secondly, the SSS law. And thirdly, the limited portability law. The reason I ask you is this. If you are interested, I prepared a comparative table of both laws, including the major decisions of the Supreme Court involving SSS and GSIS law. Second, I also prepared some written materials on the law on retirement, which is Article 2A of the Labor Code. And thirdly, I also prepared a brief statement on Articles 282, 283, 284, which are termination of employment, meaning while you can read the black letter law provisions, it is absolutely necessary that you know judicial doctrine, considering that it is an important area of law. I also prepared definitions, requirements for each item in Article 282, 283, and 284. And finally, there are also materials prepared for employment in the public sector, meaning Executive Order number 180. The reason I ask you if you have is because it's this. It's a matter of professional courtesy. I should not enter an area that is not mine. However, if you are interested, I will ask permission. I will give you the materials if you are interested. But I said I have to be very careful because as a matter of professional courtesy, I would not want to intrude in some other professor's area. If you are interested, then probably I can talk to Professor Lopez Cao if he is here and ask permission. But on my own, I would not. For some of the materials that are not my area, specifically welfare and standards, I would not feel free to give you the material. The areas that are assigned to me, I will feel free to give the material because that is my responsibility. So I'll try. If you are interested, let me know. I've talked to Attorney Lopez and probably you'll be able to reproduce the material. It's material in abbreviated form, but I lifted the major words of the decision. So you have buzzwords, in other words, you have keywords that you can always remember clearly. All right. That is so. Then maybe I can do it this Monday, because this Monday there are no classes. And I can go back to the Liman and get you the copies of the same. Clear? All right. We have discussed labor policy. We have discussed the right of self-organization. And yesterday we finished discussing the law on labor organization. Unless you have any question, we now can proceed to the next area of concern of the law, which is the appropriate bargaining unit. Well, the term appropriate bargaining unit has a technical definition, but you will note that the definition of an appropriate bargaining unit is not found in black letter law, meaning Articles 256 255 of the Labor Code merely states that it quotes the word appropriate bargaining unit, but does not contain a definition of the term. The definition can be found in the implementing rules. But before you go to the definition, it will be a lot easier for you if you imagine what a bargaining unit is. So, at the risk of being probably rude, may I ask you if you are all aware of SM department store, not the Rustan department store? Are you aware of these stores? All right. If you are aware of these stores, I do not know which one is your favorite. But at any rate, I am also equally sure that you are knowledgeable about EDSA, the Long Avenue. The long street, or it's not really a street, it's an avenue. All right, if you are, you can begin in Makati. If you look at EDSA and you are traveling towards Monumento, the monument, you will note that there is an EDSA right beside, there is an SM Schumart right beside the Hotel Intercontinental. But across it, you will also note there is a Rustan. But Rustan happens to be on Ayala Avenue. So just look at the topography, look at the geography, okay? As you move towards Monumento, and you reach what is known as crossing in Mandaluyong, which actually is Shaw Boulevard. On your right side, you will notice there is Shangri-La. That is where Rustan is situated. And on the other side, you have the Mega Mall, SM Schumart. But if you look at the Mega Mall, there are two buildings. Building A, Building B. Now note, there is a distance between the Makati stores and the one in Mandaluyong. If you move further, you reach Cubao, you will notice that there is Gateway. That's where Rustan is. And there is the SM department store somewhere inside the Araneta Coliseum. It's a big department store. If you move further and you reach almost Trinoma, you will note there's a big SM Schumart. But there is Rustan in Trinoma, right? Now look, there are geographic distances between the buildings. But if you go inside one of any of these stores, you will note that they are almost similar insofar as departmental concern is. At the basement, there is always a grocery. Now, on the upper floors, you will note also that the products are compartmentalized, meaning for the ladies, probably you will be interested in looking at the beauty products. If you look at the beauty products, and I am not saying only ladies look, probably even men do, you will notice that there are various products. Helena Rubinstein, Max Factor, Shiseido, Goguryeo. But you will notice that the ladies that are selling the products have different color of uniforms, right? But you can also go to the department further. There are those who sell ready-to-wear garments, and there are named couturiers, right? You go to SM, you have Goldberg, you go to Rustan, you have all kinds of names, right? Even just the simple jeans that all of us wear one way or the other, you will note that they are also arranged according to brands. Wrangler, Levi's, Bandolino, whatever, Fate or otherwise. Now, if you look at that, now you come to the bargaining unit. A bargaining unit is like an amoeba. The union will insist or at least try to get the best appropriate bargaining unit. The use of the word best is wrong because the law only uses one word, appropriate. But certainly the union would want a unit where it will win in a certification election, for the simple reason that a certification election can never be conducted until and unless you have determined what is an appropriate bargaining unit. The employer, on the other hand, will likewise try to get a unit where it will win in the election, because if it wins, there will be no bargaining to speak of. So the bargaining unit, therefore, is a contested area, is a contested terrain. Now, since you have pictured each one, the question you would ask is, can you have one bargaining unit for all the Stewart stores on EDSA? Or one for all the Rustan stores in EDSA? Look, there are geographic differences. There is a distance between them. Or, on the other hand, can you have one bargaining unit only for each department store? One for the Makati, one for the Mandaluyong, one for the one in Quezon City? Or can you cut them down to little compartments, meaning one bargaining unit for the grocery, one bargaining unit for the ladies, whatever you want to, you mean beauty products, whatever. Now, if you picture that, you can see the entire confusion and the entire quarrel. Why? Because one will always try to get the bargaining unit where I am going to win. Therefore, the determination of the bargaining unit becomes crucial and absolute, because it is a determining factor whether collective bargaining will work or not. Clear? So, with that in your picture, you now look at your imaginary stores and look at your black letter law. The black letter law 255 and 256 tells you, by a little imagination, what is an appropriate bargaining unit. First, an appropriate bargaining unit serves the purpose of an electoral district, similar, akin to a political election, meaning the determination of the bargaining unit, its size and its composition, will determine the area where a certification election or a consent election will be conducted. It therefore marks the boundaries. It is an electoral district. Secondly, you will also notice in the same law a statement to the effect that the labor organization chosen by the workers in a majority becomes the exclusive bargaining representative for purposes of collective bargaining for a definite period of time. Therefore, if it is the exclusive bargaining representative for a fixed determinate period of time, it now performs a second function. The second function is it is a sovereign unit. For a fixed period of time, there will only be one sovereign, although there will be a lot of aspirants to someday occupy the seat of that sovereign, meaning for a fixed period of time, there will only be one exclusive bargaining representative, although there will be several unions in the establishment. And thirdly, the appropriate bargaining unit serves the purpose of an economic unit. Economic unit meaning it identifies who will be the beneficiaries of the collective bargaining agreement if one should ever be signed at all. So, looking at the background and looking at the function, it is easy for you to determine what it really is. But note, black letter law does not specifically state a definition. So, the Supreme Court of the Philippines copied verbatim the definition of an appropriate bargaining unit, the definition accepted by the United States Supreme Court. It is known as the Rothenberg definition. I am sure you are all aware of it, regardless of what textbook you are talking about, what textbook you are reading. From 1956 to 2010, the line is straight, meaning the definition of the bargaining unit appropriate as determined by the Supreme Court is a verbatim, word for word, no deviation whatsoever of what is known as the Rothenberg definition. That is what you should memorize. Only the questions in the bar examination on the appropriate bargaining unit were all centered on that Rothenberg definition. So what is the Rothenberg definition? The Rothenberg definition can be cut into three small pieces. The first area of concern of the Rothenberg definition is what is known as the composition. Composition means all or less than all the employees of a given employer. So not composition, the key phrase is all or less than all the employees of a given employer. The term employee is defined in Article 212, and the term employer is also equally defined in the law. So going back to the examples I gave you, the employer, of course, is the Rustan or the SM. But you will note that there are consignees inside that store. There are, if you are very keen in looking, the uniform of the regular employees is not the same as the uniform of the concessionaire. And if you look at the identification tab, they are also different. That's why it is important that you know the definition of the term employee and the term employer clear up to this point. Second, now it says, how about the employer? So the second component or part of the definition is equity to the employer. In other words, it is not focused solely on the employee, it is also equally focused on the employer. Meaning, you have to consider how well the contract will be administered. That's why I called your attention to the geographic locations. Of course, you have a cell phone, you have a computer, you have an email, but they must be considered, right? And thirdly, and this is the heart of the definition, the most crucial part of the definition, and 98% of all questions in the bar examination on appropriate bargaining unit revolve around the third factor. What is that factor? How do you group the workers? And so, a straight line from 1953 to the present, the straight line says, group employees who have a common interest in wages, hours of work, and other terms and conditions of employment. Because, and here is the other half of the third factor, it is that grouping that will best achieve the policy purpose of the law. And what is the policy purpose of the law? The policy purpose of the law is maximize the employee's right to self-organization, maximize the employee's right to collective bargaining, because if they are grouped properly, group employees with the same wages, hours of work, and other terms and conditions of employment, that will assure the employee the maximum exercise of their rights. And at the same time, you are able to determine the reciprocal obligations of the employer towards the worker towards the employer. Now note, that is the definition. It has been accepted since time. The latest case that defines it very, very well, and it surveyed the decisions of the Supreme Court for the last 30 years, is the case of the University of the Philippines versus Calleja. In that case, the question was, can you form one bargaining unit composed of the members of the faculty and the non-faculty? You very well know whether the myth is correct or not is not the point. The point is, in an academic setting, the prince, the darlings, the greats are the professors, those who teach. Those who do not teach, I am not saying they are less, but in the hierarchy, they are lower for the simple reason that the function of a school is to teach. In other words, they are the line people. They are the ones on the firing line. The non-academic people are support. So to follow the language of business, they are staff personnel. Let me be sure, I am not passing value judgment. I am explaining a structure of the law. Clear? Now, there are times and moments in your life when you are mischievous and at the same time selfish. I do not know, and I have not read the background of each and every one of you, but chances are you are not all graduates of the Santo Tomas University. This is a mixed group, right? There is going to be a point in time, pardon me for saying it, there will be a point in time where you will all group, not according to the fact that you are all reviewees of this school. You will group according to the schools you came from. Why? Because you will feel comfort with your own fellow graduates, right? That is the other side, the selfish side of an appropriate bargaining unit. Let me be sure, forget that I ever said it. If I said it, it is only to drive home the point of what a bargaining unit is all about. Clear. I repeat, if you are able to imagine the stores I just mentioned, and you are able to determine and remember the functions of the appropriate bargaining unit as an electoral district. Number 2, as a sovereign unit. Number 3, as an economic unit. Then 98% of all your problems on appropriate bargaining unit is water under the bridge. The focus is just remember one thing. The law is not looking for the best. The law is not looking for the optimum. The law, in the language of the former Dean of the UST College of Law, Chief Justice Narvasa, he said, there is only one test provided for by law, and the test is only one word, appropriate. Clear. Now, if you translate the appropriate to its living reality, you will notice also that the Supreme Court followed certain criteria used by the U.S. courts. First, geography. How are the establishments located? 2, the classification of the employees. Are they regular, casual, temporary, probationary, or whatnot? The ease in the administration of the contract. But the court ended up with one warning. Not one of this is a deciding factor, because in the ultimate analysis, the appropriateness of the bargaining unit is always what Rothenberg defined: group workers, common wages, hours of work, and other terms and conditions of employment. Group them. Why? Because that is the grouping that will best achieve the policy objective of the law and best area to exercise their reciprocal rights and obligations. Clear. At this point in time, may I ask if it is clear or not? I am looking or trying to review the questions asked in the bar examination over the years, and you will know it is always the appropriateness of the bargaining unit. Whether you are using your own reviewers or not, or you are buying the bestseller of the UP College of Law with a very euphemistic title, Questions and Answers in the Bar Examination. I assure you, if you read it, you will be amused. There may be instances where your laughter will never end. And it is this. Look, I am not betraying my own institution. I am a loyal graduate of that school, and I hope I am also equally a loyal member of its faculty. But if you look, there is suggested answer. There is an alternative answer. And sometimes there are 3 or 4 alternative answers. It only tells you that unanimity of opinion is almost impossible to get when you consider that there are 10, 11, 12 members of the faculties from various law schools. Now, I'm not saying it's a bad reviewer, lest I be misunderstood. All I am saying is, you read the questions, you read the answer, if only to give you a direction where the questions will come from. The answer in the last analysis is the examiner. Whether he accepts the UP answer is correct or not is another point. But if it is any comfort to you, UST is represented in that committee that answers the bar exams. I think in labor law, the UST members of the faculty are Samson Alcantara. He always is there. Dean Abad, Antonio Abad, he is also always there. And as I was looking at your announcements, I saw his name. And he will conduct, I understand, a survey of Supreme Court decisions. So, UST is well represented in that committee. Your interests are amply protected. I am sure they will insist as answer what they said during the bar review. So you at least have comfort. Now, go back to the more serious one. The law allows the parties to determine by agreement what is the size and composition of the appropriate bargaining unit. But if the parties are unable to do so, then the Bureau of Labor Relations will have to determine what is the appropriate bargaining unit. And an appropriate bargaining unit is an interlocutory order insofar as determination is concerned. It is not immediately applicable. It's not immediately appealable, clear? So, having said that, there is the question, therefore, of size. Size is a factor, but it is not a decisive factor. Now, you are all aware of 3 cases. One, the Diatogon case. Second, Indophil. And third, the security agency cases. Why are they important? Because the 3 cases answers one fundamental question. Will labor law allow, borrow, what is known in corporation law as piercing the veil of corporate fiction? Corporation law tells you that corporations are separate and distinct from those who own the corporation, namely the stockholder. Second, one corporation has a personality of its own, separate and distinct from that of another corporation, even if they are commonly owned. Commonly owned means they have common stockholders. Because they have common stockholders, it is also possible that they have common officers. If they have common officers, would that commonality be sufficient to pierce the veil of corporate fiction? Meaning, all separate corporations can be joined into one bargaining unit. Now, the first group of cases, Diatogon and Indophil, laid down the doctrine that corporations are separate and distinct one from the other. And while there are commonalities of ownership, and there may be a relationship with one with the other, even if they are situated in a common compound, the piercing the veil of corporate fiction will not apply. That is the first group of cases. The second group of cases are the security agency cases. And it goes back to the old original doctrine of the courts, the La Campana company case. These are familiar cases to you because you have studied corporation law. In all probability, each one of you has a burning ambition of being a corporate lawyer someday. So it is not difficult for me to explain it. In the security agency cases, it involved 3 security agencies. But the question is, the court applied what is known as the unitary aspect of management. What is it? The 3 agencies had a pervasive, overriding, unitary aspect of management. Pervasive, overriding, unitary aspect of management, meaning the 3 agencies had common owners, had common directors, had common anniversary dates, had common wage and salary structure. The workers, namely the security guards, were easily transferable one over the other, and secondly, there was a pervasive unitary aspect of management. Because there was a pervasive unitary aspect of management, the court was able to pierce the veil of corporate fiction and said all 3 agencies must be joined into one bargaining unit. So what is the moral of the story? The moral of the story is, as best as you can, use the factors. If you use the factors, just follow one rule. Not one factor is decisive in all cases. But the factors, if you join them together, you now look what will best achieve the policy objective of the law. The policy objective of the law is there must be an appropriate bargaining unit. Otherwise, there can be no election and there can be no collective bargaining. So, a prior agreement will not bind the parties, meaning there is no such thing as a permanent appropriate bargaining unit. There is no such thing as the best appropriate bargaining unit. There is no such thing as the optimum bargaining unit. There is only one thing: is it appropriate? And the way to answer what it is appropriate is to follow what Rothenberg said. Group workers according to wages, hours of work, and other terms and conditions of employment. But if you want to be very curious, it is not really the workers you are joining, it is the positions. Because the position will always be there, but the worker can change. Although, I repeat, that is for classroom discussion, not for the bar, because the Rothenberg definition uses the word employee. Clear? Do you have any questions? So, if there are changes over time, then there is a ground to determine whether the appropriate bargaining unit of yesterday will still be the appropriate bargaining unit of tomorrow. And lastly, it will never bind any other union, not a signatory. It will not also bind the signatory union if conditions should ever change. So there is no permanent bargaining unit. It is there merely because that was the best way of solving the position. But regardless of what, you can always remember it very easily because Mr. Chief Justice Narvasa, UST's pride in remedial law, used the word appropriate. Well, I'm sure those of you who are UST graduates will always remember the greats in remedial law: Narvasa, Benipayo, Peria, and the lady judge, her name, Elipanit. All right, do you have any questions? Do you have any questions on the appropriateness of a bargaining unit? Well, I don't know if you are statistics conscious. If you are statistics conscious, according to the records of the Supreme Court, and the lawyers took their oath yesterday, UST had a high passing average, I think to 70%. It's above the national average. All right, any questions? That's why I'm even scared to accept a teaching appointment, usually. All right, any questions on the appropriateness of a bargaining unit? Any questions? All right, if there are no questions, we can move on. Now, there is already an exercise of the right of self-organization. There is already an existing union. There is now an appropriate bargaining unit. You have one more before you can begin to bargain. Because a union and an employer will bargain only if the union represents a majority of the workers' choice. Clear? But then, may I ask you to read very carefully your textbook, because this is the controversial area. Read Article 256, 257, 258, and then read voluntary recognition in the implementing rules. Give you 5 minutes to read it, because it is a highly controversial area, and all bar reviewers had a hard time trying to explain the relationship with one with the other. But it will be a lot easier if you read carefully 256, 257, and 258, and then read the voluntary recognition clause in the implementing rules. Read it. All right. If you are reading it, may I ask you another thing? Are the cases of Colgate-Palmolive versus Blas Ople and Samahan ng mga manggagawa sa top form in your textbooks? Or are they also part of your little labor law code? Take a look. Are they there? I have to make statutory reference and a guide simply because there is the voluntary recognition clause in the implementing rules. So will you please take a look? Do you have Colgate-Palmolive versus Blas Ople and Samahan ng mga manggagawa sa top form factory? Whether you are holding a reviewer, you are holding a textbook, or you are holding a coder provision with some little commentaries, may I ask you to please take a look if it's there. Just to give you a background, there is an essential requisite that an employer-employee relationship must exist between the employer and the workers. Absent an employer-employee relationship, certification election, consent election is moot and academic. Why? Because absent an employer-employee relationship, there is no need to conduct an election because there will be no bargaining at all. So the essential requisite, therefore, is employer-employee relationship. Clear? I repeat, absent an employer-employee relationship, there is no duty to bargain. There is no duty to bargain, there is no need to conduct an election. Clear? But to go back to Article 255, you will notice, and it says, the labor union that obtained a majority of the valid votes cast is the exclusive bargaining representative. The key phrase, majority, which is 1/2 plus 1, of the valid votes cast, that is the base, becomes the exclusive bargaining representative. How then does one become an exclusive bargaining representative? To give you the background, forget voluntary recognition first, and I will do it historically so you can determine it easily. Article 256, take a look at the heading, petitions for certification election in organized establishments. Article 257, in unorganized establishment. Article 258, petitions filed by the employer. So, going back to the blackboard, you know, a majority union becomes a majority because it is the worker's choice. If the worker has chosen it, it is the exclusive bargaining representative. But the only way you can do that is to conduct a certification election or a consent election. Clear? But the question became complicated because after the decisions of the Supreme Court in Colgate-Palmolive and Tapon, the question of voluntary recognition entered the picture, not by an amendment of the law, but by the implementing rules. And you will note that under Article 5 of the Labor Code, the Secretary of the Department of Labor and Employment is authorized to promulgate rules and regulations to implement the provisions of the law. But I am also equally sure that when you took your review on labor standards law, you were told that the Secretary of Labor cannot amend the law under the guise of interpreting the law. So you have the picture clear. Article 255 and Article 256 and 257 are related in the sense that the union that obtains a majority of the valid votes cast is the exclusive bargaining representative mentioned in Article 255. Clear. Article 258, on the other hand, is also equally related because a union will have to be made as a choice. Clear. How do you use 256, 257, and 258? You cannot use them all at the one and the same time. If you look at Article 256 and you look at Article 257, you will note one thing common between the two. A petition for certification election. In Article 256, organized establishment, or Article 257, unorganized establishment, the petitioner is the labor union. But that because the petitioner is a labor union, you have to read Article 242 also, because only a legitimate labor union can file a petition for certification election. So before Article 256 and Article 257 becomes operational, you must meet the first condition. The union, as the initiating party, must be legitimate, because if it is not legitimate, it cannot file the petition for certification election under Article 242, which says These are the rights of a legitimate labor union. That's clear. Now, how then do you distinguish Article 256 from Article 257? Both speak of certification election. The dividing line between the two is Article 256 says it is organized, O-R-G-N, organized, when is an establishment deemed to be unorganized, as distinguished from organized. Article 256 says an establishment is deemed to be organized if there is an existing valid collective bargaining agreement in full force and effect. Meaning, there is a collective bargaining agreement. However, while it is not found in black letter law in Article 256, you will note that if the union exists and it was certified an exclusive bargaining representative, the law allows the union 1 year to negotiate a contract simply because you have the 1 year bar rule, which means therefore an establishment is deemed to be organized if A, there is an existing collective bargaining agreement, or B, there is a union that is certified and it is 1 year given a period to negotiate a contract. Clear? Article 257, on the other hand, speaks of unorganized establishment. Unorganized establishment means there is no existing collective bargaining agreement, and there is therefore no union that is recognized, although there may be unions in the establishment. The second distinction is, you will note that under Article 256, there is a requirement of substantial support. And secondly, there is what is known as the freedom period. The period during which time a petition for certification election can be filed. But if you look at Article 257, you will notice that all the requirements mentioned in Article 256 are absent in Article 257. They are absent, right? Now, how do you distinguish Article 256 and Article 257 on the one hand, and Article 258 on the other? Article 258 is a mechanism provided for by law to allow an employer to file a petition for certification election only under the condition that the employer was asked to negotiate, but the employer doubts the majority status of the union. Clear? So, you have identified who is the petitioner. Now, whether the petition is filed under Article 256, 257, or 258, the mechanics of the election are found in Article 256. It speaks of certification election, runoff election. Clear? Alright, having said that, take a good reading again. It will become easier for you to follow me. Oh no, it's easier for you to understand rather than following me. Alright, read it again. Okay, so let me begin with Article 256. The petitioner is a legitimate labor organization because if it is not legitimate as defined in Article 212, it cannot avail of the rights provided for under Article 242. Second, the petition for certification election must be verified, accompanied by a substantial support rule. First, if the petition for certification election is not verified, it is not a jurisdictional issue, meaning all that will happen is to return the petition and have it verified. Second, you have what is known as the substantial support rule. The substantial support rule, if you look at it carefully, is a percentage of the membership of the appropriate bargaining unit supports the petition for certification election. It is arithmetic. Arithmetic plus determining the base. The base is all the workers, whether members of the union or not, form the base. It is from that base that you extract the percentage. Is it 25 or is it 30? Is it 25 or is it 30? 25. Now it's easy for you to remember because 25 is uniform all over the substantial support rule. Clear? They support the petition. The question is, the substantial support rule applies only in petitions for certification elections, but not in motions for intervention. Because the law clearly uses the word certification election, meaning the percentage substantial support applies only in certification election petitions, not in motions for intervention. Clear? Now, when should you show substantial support? The recent modern rule says that substantial support need not be shown at the time of the filing of the petition. It can be shown at a reasonable time thereafter, prior to the holding of the election. Second, the union, that is a rival union, has no right to question and verify the substantial support compliance. Verification of compliance is lodged with the Department of Labor, not the labor union, that is the rival union. Clear? Thirdly, if the substantial support rule is eroded by way of a withdrawal after the filing of the petition but before the actual conduct of the election, the withdrawal will have no effect on the validity of the election, the theory of the law being, if there is a withdrawal, it will best be proved by the results of the election. Clear? And finally, you have what is known as the discretionary rule. The discretionary rule says that in order to achieve the policy objective of the law, the Department of Labor and Employment is given the discretion to order an election even if there is no compliance with the substantial support rule. Now, if all the requirements are present, and this was the question in the bar examination, certification election will become automatic. it is now mandatory that an election should be held. Now, having said that, start looking at Article 257. You will note that Article 257 has a commonality with Article 256 in the sense that Article 257 can be invoked by a union if and only if it is a legitimate labor organization. Again, because you have Article 242. But you will note this time that Article 257 is completely silent insofar as period, meaning freedom period, second substantial support rule are totally absent under Article 257. All that it is required is file a petition for certification election by a legitimate union. What is the reason behind? The reason behind is the intent of the law is to bring in a labor union, because absent a labor union, there can be no bargaining, and you cannot implement the policy objective of the law mentioned in Article 13, Section 3 of the Constitution and Article 211 of the Labor Code. Clear? Now, Article 258, on the other hand, states that the petitioner in this case is the employer, but the employer can file the petition if and only if it is requested to bargain collectively and the employer doubts the majority status of the union. So you have therefore answered, when do you use Article 256? When do you use Article 257? When do you use Article 258? Clear? So you are still talking of certification election. Clear? Now, how about the mechanics of the election? Read Article 256 and you are going to be introduced to certain terms. Votes cast. Second term, majority of the valid votes cast. Third term, the combined votes of all the participating unions equals 50% of the votes cast. And lastly, you are introduced to the concept of certification election. And secondly, run-off election. And note that Article 2587 and 258 has been amended. There is Article 257-A. Clear? Alright. Now, read very carefully Article 256 because it is arithmetic. Whether you like it or not, that is going to be the question of arithmetic. Read it very carefully. First area of concern is when is an election validly held? And you are introduced to the concept of votes cast, right? Second, exclusive bargaining representative, and you are introduced to the concept of majority of the valid votes cast. And thirdly, you have a runoff election, and you are introduced to the concept, the combined votes of all the participating unions equals 50% of the votes cast. It's arithmetic. May I ask you to read it very carefully, and then we will go and explain it. Here now, an election is going to be conducted. It is a certification election. How do you determine if the election is validly conducted? The base is 50%, or is it a majority? Read it. So it is 50% plus 1 of all the qualified voters cast CASTS their votes. What does it mean? It only means that the voter voted. The question of the validity of his vote is totally irrelevant, right? Clear? Yeah. How do you determine which choice won? In a certification election, there must always be a no-union choice in addition to the union choice. In a certification election, a no-union choice is always a choice available. It is not a choice available if it is a runoff election. A no-union choice is available only in certification elections, not in runoff elections. Clear? This time it says, the choice, in order to be determined as the valid choice, it must receive a majority of the valid votes cast. This time, your base has become different because majority is 50% plus 1. But the base of the majority is the valid votes cast. So two possibilities will happen. If there were only two choices, Union A and no union, and not one of the choice obtained a majority of the valid votes cast, that is the end of the certification election, and no runoff election will be conducted. But if there were at least three choices, meaning two unions, Union A, Union B, and no union, and not one obtained a majority of the valid votes cast, but the combined votes of the two participating unions equals 50% of the votes cast, then a runoff election can be conducted. Note, there must at least be three choices, and the combined votes of all the participating unions equals 50% of the votes cast. Read it, read your law, because your formula must be clear in your mind. Read it now. Three choices, and the combined votes must be equal to 50% of the valid, or is it the votes cast? Is it valid or is it the votes cast? Hmm? Is it 50% of the valid votes cast or 50% of the votes cast? Alright? I'm not being makulit. No, that's not my intention. But you're talking of arithmetic. And whether you like it or not, in any language, 1 plus 1 is 2. The only way you can claim you are not knowledgeable in arithmetic is if you are a member of the COMELEC. Clear. So that's clear. Now, for a runoff election to take place, the no-union choice is going to be eliminated. The competitors will only be the unions. The 2 unions that obtain the highest number of votes, except if there is a tie. If there's a tie, then they will have more than 2. But no union is going to be eliminated. Why? Because the union, the intent of the law is to bring in the union. Clear? 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 All right. 10 more minutes and you'll have the break. I called your attention to Colgate-Palmolive and Samahan. Right? In the case of Colgate-Palmolive and in the case of Samahan, it all revolves around the union chosen by the workers is the exclusive bargaining representative. But going back to Article 256, 257, and 258, you will notice secrecy of the ballot. There is freedom of choice secretly made, meaning there is an election. Freedom of choice secretly made. Clear? What do you mean by that? In the case of Colgate-Palmolive, and I ask you to take a look at it in your books, the Supreme Court said that the Secretary of Labor, which happened to be in this case Blas Hoppler, has no authority under the law to designate a union as an exclusive bargaining representative without conducting an election. Meaning, proof of majority status other than a secret ballot is not acceptable. And when the Secretary of Labor did that, according to the court, it exceeded its jurisdiction and its act is invalid. Alright? So what is the intent of the law? Freedom of choice secretly made in an election. The violator in this case is the Secretary of Labor. In the second case, which happens to be top form, the employer voluntarily recognized the union without conducting an election. And the court said the act of the employer is against the law because the intent of the law is secrecy of choice. The act of the employer, in effect, certified the union without an election. So what? It means that the Supreme Court was specifically and strictly enforcing 256, 257, 258, and the common ground is secrecy of choice. Freedom of choice secretly made. Correct. But you have the case. I'm still speaking of the law without the rules. You have the case of the Warren Manufacturing Company and Algeria. But these cases were decided not on certification election, but a consent election. But then you must remember that the doctrines are no longer applicable today. simply because of the statement saying that a consent election has nothing to do with certification election. Clear. The doctrine is intact. Article 256, 257 is also equally intact. Clear. So what happened? What happened was, after the two decisions were promulgated, the unions were able to convince the Secretary of Labor to amend the implementing rules and brought in the concept of voluntary recognition. Now, voluntary recognition in the labor code is couched in such a way that it becomes attractive but minus the secrecy of choice. Why? Voluntary recognition says the employer can voluntarily recognize the union under certain conditions. Condition number one, there is only one legitimate labor organization in the company or in the establishment. Second, the fact of voluntary recognition is reported to the Secretary of Labor and publicized within the establishment. The question is that a valid amendment by way of interpreting the code? That question has never been answered. It has never been answered because it has never been judicially questioned. That's why all bar reviewers last year took pains in pointing out that if the question of that nature were to be asked in the bar, you have to explain 256, 257 in the light of the two doctrines, Colgate-Palmolive and Samahan, and the implementing rules on voluntary recognition. Now last, before you take your break, consent election now under the implementing rules can have the same effect and result as a certification election. Why? Because when a petition for certification election is filed, the med arbiter can ask the parties instead to conduct a consent election, and it will be duly recorded, and the result of a consent election will be the same as a certification election because it will result in the certification of the exclusive bargaining representative. Clear? All right, I think I have detailed you for 2 hours. So you need a break. You can figure out 256, 257 amongst yourselves. You can concur, you can dissent, you can concur in part, you can dissent in part, and all you have to do is to put your name and then put the letter J behind your name. All right, you can have a break. You can have 20 minutes of break.
na.
Yun na, yung pag-uusapan yung ano na ito sa option party nila. Yung pinag-uusapan ng employer at